Recording in progress.
Good morning. My name is Rachel Ndapo, Chief Audit Executive, SSA. Thank you.
Good morning. My name is Maila Mantata, State Security Agency.
Morning, Dumisa Muteto, Acting GDG, Counterintelligence.
Thank you very much. I think people don't usually see you. They must be glued to the to their TVs. Okay, can I hand over to the minister then?
Good morning, Chairperson and members of the committee. This morning, we want to appreciate the opportunity and the invitation by the ad hoc committee provided to the SSA to then respond to the issues that have been raised during the consultations of the GLAP. We also want to appreciate the efforts of this committee on making sure that you work even on weekends to ensure that this bill is finalized through a meaningful public participation process. The public participation hearings also provided us the opportunity to make assessments of whether the bill sufficiently addresses most of the challenges that confront us. And in this regard, we are going to be submitting additional proposals to the bill. This, for example, is the counterintelligence responsibility of the South African Intelligence Service, what is in general will be called, which will be the Foreign Service, and also a provision for departmental intelligence by the Foreign Service, which is the service. This is to mirror the work that is already done currently, but also the work that is done by domestic services, which will be the agency upon Parliament finalizing the bill and the President accenting. We remind ourselves that the main objective of the bill remains to de-establish SSA and establish two services, which are the agency and the service, or the domestic service and the foreign service. And if you recall, we once made a mistake in the past of establishing SSA through a proclamation instead of establishing the service through the act as required by law. And we are confident that the two services will be able to be established through the law. We are also fully aware that the work that you are doing contributes to assisting us to implement the recommendations of the high-level review panel, and also to address the Constitutional Court ruling on the interception. But from the public participation and the hearings thereof, we are aware and noted that not all the issues that have been raised can be addressed through the law. And some of those issues will have to be addressed through the regulations, with the provisions that have already been proposed for the minister to make regulations that are applicable. On that note, Honorable Chairperson, the Acting Director General has informed me that on behalf of the SSA, DDG Mashele will then make the presentation in terms of our responses to the issues. And with your permission and through you, if I may hand over to DDG Mashele. Over to you, ma'am.
Thank you very much, Minister. Thank you, Chairperson. The Chairperson, we them to the report that was sent to us yesterday, and we attempted to address all the issues that required our comments. And the format of the document is we have reflected on what each of the intelligence services and parties consulted recommended. And the last column reflects our response to the issues raised. So the first part of the document relates to issues raised by the Office of the Inspector General of Intelligence. And it relates first to the monitoring aspect, which they are proposing should be included in the bill to ensure that they are able to oversee, examine, and evaluate, investigate compliance of the services with the Constitution and applicable laws. Our response is that we support the proposal, but we are recommending that instead of using the word service, they should reflect national intelligence structures, which then would be applicable to all the national intelligence structures as defined in the bill, so that not only the South African Intelligence Service would be monitored, but they would be able to monitor all the other structures. In relation to their input on review, we support the proposal. With regard to significant intelligence failure, we suggest that the word comply be replaced with the word fulfill, because our view is that when we say comply, it might result in a superficial exercise of just ticking the boxes, if we can put it like that. Because we feel that if a mandate is fulfilled, then the Inspector General would be able to audit that. With regard to unlawful intelligence activity, we suggest that the use of the term be expanded to include illegal, so that it reads unlawful and illegal intelligence activity. And we think that this presentation would then cover not just what is unlawful, but that which is done without any legal basis. In terms of fair presentation, we support the proposal. And with regard to the definition of intelligence, we propose that the definition as proposed in the GLAB be used as it is consistent with the provision of the National Strategic Intelligence Act of 1994 as amended in 2013. We also agree that the citation to the Constitution is removed from the bill. And with regard to the scope, where the Inspector General is proposing that the services and intelligence services entities be amended in relation to the definition, we support that. But we also propose that there be consistent use of the term national intelligence structures, as it would cover the intelligence services, defense intelligence, and sub-CI. With regard to reports on monitoring and review of investigations containing findings and recommendations referred from the JSCI and designated complaints, our proposal is if the IGI's findings or recommendations are binding, then that would expose the IGI's certification process to legal review. We therefore propose that where there is disagreement, the minister intervenes, and if that fails, the matter be referred to the Joint Steering Committee on Intelligence for a final adjudication. In relation to the IGI's responsibility to perform functions designated by the Joint Standing Committee on Intelligence, our response is that we will be guided by the JSCI on this proposal and will comply with what the JSCI finally pronounces. We continue with the input from the Office of the Inspector General. The next a provision that they are requesting consideration of is that the Inspector General be empowered to determine his structure, functions of the office, conditions of employment, and security requirements of the members of that office. Our proposal is that the IGI's presentation would result in a third scheduled department. And we think that the high-level review panel recommended the establishment of two services, being the foreign service and the domestic service. We also note that the impact on the budget might be negative, and to remedy that, we are proposing that regulations in a shared service model be put in place as the issues raised by the Inspector General and NCOP are understandable in relation to their autonomous functioning. Moving to 6. It would be point number 14. I think point number 13 is already covered. The provision that the minister acting in concurrence with the committee must make regulations regarding the performance of the functions of the IG. We support the proposal, but we will be guided by the pronouncement of the committee. General provisions in relation to the definition of intelligence gathering. Our proposal is that we revert to the definition that is reflected in the National Strategic Intelligence Act of 1994 in relation to intelligence gathering as the acquisition and processing of information, which includes correlation, evaluation, and analysis of such information. The inclusion of dissemination in the gathering process is not supported by the SSA because we think that that is a separate step, especially in the intelligence cycle. With regard to clause 2, which refers to the provision for the agency to be able to impede and apprehend members suspected of contravention of the Act, we are agreeing that the word apprehend should be removed from the bill and that the agency should not have powers to apprehend, but rather to impede and neutralize any threat to national security in a prescribed manner before it manifests. And with regard to periodic briefings to the Joint Standing Committee, members of cabinet, premiers, parliamentary and presiding officers, and the Chief Justice. The IG submission is that the scope of parties included and excluded in this provision should be reviewed. We agree that it should be reviewed, but we propose that we will create a framework for periodic briefing of the parties as indicated, as this was also a provision and a requirement from the commission that dealt with the July 21 unrests. The definition of civilian intelligence structures, we agree that it will be amended to make provision for any other entity established in terms of the Act. That would include, for example, the academy, the center, and other structures within the agency. With regard to a labor relations matter, where the Inspector General is suggesting that members of the civilian intelligence services may not go on strike, nor may the employer cause the lockout of a member or a person. We support the proposal, and in addition, as continued in clause number 32, where the Inspector General is proposing the establishment of an alternative instead of alternate dispute resolution mechanism. We support the proposal, and we also say that the existing regulations will be reviewed to enhance the consultation and dispute resolution mechanisms. We then move to issues raised by NCOP, chairperson. So NCOP submission is that the service should supply intelligence relating to threats and opportunities to NCOP. And we are saying we agree with that, but the provision should make it obligatory for all national intelligence structures to supply intelligence to NCOP. NCOP further proposes that the agency that cabinet should be excluded from the list of parties that must be briefed by the domestic service. But we are saying that this is a provision that we think should remain in the bill. And because once the national intelligence priorities have been determined, the national intelligence structures must then determine the operational plans on which cabinet would need to be appraised. NCOP further proposes that NCOP should be able to co-opt relevant stakeholders when the need arises. Our proposal is that intelligence structures are defined in law, and if there is a need for NCOP to be briefed by a specific department or entity, NCOP can invite that entity to brief on specific information requirements. But we also say that the regulations on intelligence coordination, which were already presented to the JSCI, will be used to ensure that issues of co-option and invitation and provision of information to NCOP are adequately addressed. NCOP also raises an issue similar to that raised by the OIGI in terms of the appointment of persons and administrative support to NCOP. And our response to that is that the provisions that we indicated in relation to the OIGI, that we will review the shared services model to ensure greater autonomy, is also applicable to NCOP. In relation to the budget of NCOP, where NCOP is proposing that the budget of the office of the coordinator be appropriated by Parliament as part of the budget vote of the Intelligence Service. We are saying we agree with the proposal, but that the NCOP budget should be ring-fenced, similar to that of the IGI. We move, Chairperson, to the issues raised by crime intelligence. Crime intelligence raises an issue relating to the definition of cybersecurity in the cybersecurity bill, and they indicate that it is being promoted by the Department of Justice and Constitutional Development. Our response is that the bill is actually being spearheaded by the State Security Agency, and we are in agreement with what crime intelligence is saying in relation to aligning the definitions between the cybersecurity bill, what the cybersecurity bill provides for, and what GLAP provides for, and we will ensure continuous alignment throughout the process. Crime intelligence further indicates that we must review the definition of domestic intelligence and foreign intelligence, and we agreed that we will review that, but that we will refer to the definition that is in the 1994 Strategic Intelligence Act. They further propose that the security competence test should be referred to as the security competence assessment, and we agree to the proposal, and we propose to change reference to the security competence test to security competence assessment throughout the bill. In relation to definitions, these are issues that were raised throughout the report by various entities as well. We note the definition to national security and the proposal that is in the report that says national security should be the protection of the public's interests, citizens, institutions, and sovereignty from internal and external threats as governed by the principles set out in Section 198 of the Constitution is supported by the SSA. In relation to reference to opportunity or potential opportunity, the submission is that opportunity or potential opportunity is ambiguous and could be subjective, and the definition could be open for abuse. We support that the definition that is in the bill be retained with the deletion of the word potential opportunity, so that we only remain with opportunity and threat instead of potential opportunity and potential threat, with the understanding that intelligence responsibilities are to forewarn and anticipate threats. Further issues relating to definitions, Chairperson, is the matter of person or institution of national security interest. The proposal is that the definition should be limited to any person or institution suspected of espionage. We propose that the definition be narrowed down so that it retains the national security threat as is reflected under paragraph 31. The threat to national security the proposal is that the bill does not define threat and that we should insert a definition as impending danger of serious harm to the Republic as one sovereign democratic state founded on the values set out in Section 1 of the Constitution. Our submission, Chairperson, is that the word threat is used in the context of the threat to national security, which is defined in the bill, not in broad terms. We have also reflected on the issue of security competence test, and our proposal is that the bill should make reference to security competence assessment throughout, instead of what is reflected in the proposal, which would be limiting. In relation to domestic intelligence and foreign intelligence, the definitions, we propose to revert to the definition that is in the National Strategic Intelligence Act, which reads domestic intelligence means intelligence on any internal threat or potential threat, but add the word opportunity to national security. And the same would be reflected in terms of foreign intelligence as is currently in the Act, Chairperson. The issue of intelligence gathering, we have already addressed that, but we also indicate that we propose to maintain the definition that is in the bill. We have also reflected on the use of the word apprehend, and we agree that the word should be removed from the bill, and we rather use the word impede and neutralize, as this is consistent with the definition of counterintelligence in the Act. Clause 39, Chairperson, there is a proposal to conduct security competence tests on categories of applicants and employees of organs of state to issue or decline to issue a security clearance certificate. We are saying, Chairperson, that we would propose to add or to expand on that definition and have a definition that talks to us conducting security competence assessments on categories of persons or institutions referred to in Section 2A of the Act in order to issue or decline a security clearance certificate or to detect threats to national security. It is the same amendment, Chairperson, that we refer to under clause under paragraph number 40, the broadening of the definition of security vetting. With regard to bulk interception, Chairperson, in our initial presentation, we had conflated what is supposed to be targeted or legal interception with bulk interception. Our submission is that bulk interception will be limited and be exclusively used within the foreign jurisdiction, and that the Inspector General will conduct continuous oversight and provide assurance to Minister and the Standing Committee that bulk intercepting activities are not directed at individuals in the Republic and that the activities are in compliance with applicable laws and directives. In relation to interception and surveillance of communications within South Africa, we propose that the Minister introduces a bill to address that specific issue. With regard to a question raised on person or institution of national security interest, we propose that the definition should be any person or institution identified by the agency in the form and manner prescribed that engages in activities that are defined as a threat to national security in terms of the Act. And reference to national security is also included in that definition. In relation to the provisions that follow Chairperson number 44 on opportunity, domestic intelligence, foreign intelligence, intelligence gathering, national security intelligence, security competence test, we have already provided the responses as above, and we wanted to ensure that where the committee had raised issues, we reflect on them and ensure that we provide responses. And that is also applicable to amend the proposal to amend the vetting investigation in relation to persons or institution of interest. We have addressed that. Chairperson, I don't know if the copy that Chairperson has also has the issues that Minister raised in her introductory remarks that we would like the bill to address two additional issues. The first one being to add a counterintelligence mandate with regard to the internal operations of the Foreign Service in relation to their personnel and operations. And the second one in relation to their departmental intelligence mandate. My apologies, Chairperson, it was one page down. I'm not sure if a secretary received the copy. Minister, thank you very much. That concludes our presentation. Thank you, Chairperson.
Thank you very much, Minister.
Thank you, Chairperson, and that's our presentation. But there are a few issues I want to expand on the issues around NCOP and OIGI in terms of their request for making appointments and the structures. The current arrangement is indeed limiting, but we have been working with both in terms of improving that does not require an amendment of the law, because it will make them both referees, players, and everything. Even the limitation has been, we have not done comparative with how the public service works, but in terms of the engagements that we had then started to say, we'll then do comparatives of how the public service works. And I would like to give an example. The most basic position in the IGI, we have not dealt with appointments since I've taken over the responsibility. Those positions are approved by the minister, but those things could have been sorted out on the delegations to make sure that the minister, like in other government institutions, delegate appointments to the inspector general or the head of institution up to a particular level, and then the other ones then gets consulted with the minister. The challenge of just removing and giving them all the powers, it gets them to become a Schedule 3A entity, which will then go against what the high level review panel proposes by the strain on the budget and the national fiscus. And equally, in the budget administration, we've improved that since we took over the responsibility of giving the IGI and NCOP certain delegation as it related to the budget. And these were the things that we came across in terms of operation. There's no need, and if you recall, we do not have as SSA a vote on our own. Our vote is allocated through the National Treasury. So if you say Parliament must then allocate a vote for NCOP and IGI, we are then going to then change the current arrangements, including on SSA. So so for us, we think the shared service model that we've been working with and consulting on will work. But in addition to that, NCOP, in terms of the intelligence coordination regulations that we are busy finalizing, the proposals that are there will strengthen the ability to be autonomous and not be subservient to the Director General of the agency. The second issue that I'd want to put emphasis on is the issue around the bulk interception, where the conflation took place. In any other jurisdiction, bulk interception is for foreign services. If you recall, the US government got into trouble for using on the Snowden matter, for using bulk interception domestically. And we are saying we want to then separate bulk interception from targeted interception and surveillance, and we'll bring this the submission. The OIC is working on that. You'll recall when they were invited to make a submission, they indicated that their interest would be on that separate law. But to assure, or for assurance that there won't be abuse of bulk interception and then be used domestically, we're saying we need to put in this bill the provision that the IGI must then do oversight and report continuously to the minister and the standing committee. Why is that important to make that provision and not say in the course of his work or her work, the IGI will then do that? Is because the IGI, like any other oversight body, they sample what they are going to focus on in a year. But we are saying if we provide for it, then it's not a sampling matter, it's a matter that they must do continuously. That's why we want to specifically mention. It will assure both the members of the public that there will not be use of bulk interception by the agency, or what today we'll know as the domestic service, so that we can protect the privacy of South Africans and the infringement of the rights of South Africans. Will then govern the targeted surveillance and targeted interception and surveillance, and in line with the initial proposal that includes the designated judge in the new law on interception and surveillance for the OIC. That we're going to bring to Parliament, which already started working on. The other matter that I'd like to put emphasis on is on the conducting of security competence assessment on categories of persons and institutions in order to issue or decline security clearance certificate or to detect threats to national security. We're then saying, given the other obligations that we have in terms of FATF, and what the country is required to be able to provide in FATF for the fight against counterterrorism and all other things, we are proposing that we go and expand the definition of vetting, because the current definition of vetting limits vetting for purposes of issuing a security clearance certificate. But we are saying let's expand that definition or broaden that definition to include for vetting for purposes of identifying and detecting threats to national security, where national security has already been defined, and it will be done in a prescribed manner. With that, Chairperson, we are submitting our issues to yourself, including the 2 additional amendments on the counterintelligence for the service, which is foreign, that we had already proposed and Ms. Mashele referred to, and we submit to yourself. Thank you.
Can I maybe request that you repeat the additions that you are talking about? Only those additions.
Thank you, Chairperson. Our our proposal, Chairperson, is that the foreign service be mandated to conduct counterintelligence with regard to its own personnel and its own operations. By that, we mean the foreign service should be able to conduct security competence assessments for its members, be able to provide the necessary security for their operations abroad, so that that mandate is not left with the internal service, which is the agency. That is a provision that existed in the previous law, but for some reason it fell off when we were discussing the bill. We think that that is a provision which will make it possible for the service to function effectively and not rely on the domestic service to protect its operations. The second provision, Chairperson, relates to departmental intelligence. The bill currently indicates that the service will gather, correlate, and disseminate intelligence to NCOP. So provision is only made for NCOP, and there's no provision made for departmental intelligence. So we are saying that the provisions that are reflected for the domestic service should also be reflected for the foreign service, because the foreign service also has to provide departmental intelligence to specific departments aligned to its mandate in the foreign environment. Thank you, Chairperson.
I think that is very clear. Okay. Maybe if I was to open up for clarifications and questions, maybe we are on what the minister said to.
I take the point that you're saying it's clear, but it's not clear to me if it's not in writing. I'm not sure whether there is no way that it can be forwarded to us in writing in the course of our meeting so that we can interact. A veteran like you, it's easy to grasp. So to me, it's not clear, Chair.
Okay, I think that can be done. Maybe if I was to start with this one, because as a veteran, I might forget. Okay. In terms of vetting, the minister said something about adding the clause or something that should explain vetting, because now it's only focusing on people who are going to have access to classified documents. There was a suggestion that it be extended to cover even to broaden it up. Let me just say, maybe to clarify, it means it's going, because my understanding is that vetting itself is voluntary. So, except maybe, yeah, it's voluntary for every other person. If you don't want to be vetted for a job or something, then it means you lose the job. But you can't force a person to be vetted. So if you want to vet maybe a person of national interest would be Bushiri maybe, it means he might refuse because there's no act that says that is compulsory. Because you are getting into that person's privacy, which is in the Constitution, and so on and so on. The addition, yeah, maybe let me put it as a question, and then from there, let me open up to the members for clarification and question. In that order, Honorable Kulabana. Okay.
Thank you. Thank you, Chair. Chair, it's interesting to me that despite having had at least 7, if not more years to draw up this bill, the process was interesting to me in that we were suddenly as a committee reading opinion editorials about a bill that we hadn't seen. So many in civil society, including that bill circulated, included many unconstitutional sections which threatened churches and NGOs and the like. And that rather muddied the waters for us and made civil society very suspicious and of the motivation and very, or necessarily, I suppose, hyper vigilant in terms of the intentions of the bill. That being said, if the department now accepts that phrases such as opportunity or potential opportunity must be scrapped, I have to ask how this vague wordage went right through the process and through cabinet was accepted when at a single reading, it seemed to us, we were all questioning how did words and phrases like that get into the bill in the first place. So that's very concerning to me. It's as though there's some motive behind this that was driving it through. And it's quite a relief to see that in many of the instances now, it's being accepted that yes, they are a problem and should be taken out. I see there's still some call for a security competence test. Again, I don't know who would have come up with an idea to test swathes of people in the off chance that one of them might fail this. But again, equally threatening to our citizenry, saying if you don't get a competency, or not competency, that's a firearm, security competency test, you would have to shut down your entity, your church, or whatever we determine. I found that idea doesn't belong in South Africa. It was very bizarre. And we've obviously looked at that very closely. The idea that NCOP and the IG, I mean, everywhere, including in the high-level report, it says they must have far greater independence than they currently do. I mean, we heard tales of even secretaries being appointed by the SSA for the people who should be overseeing them. It obviously is not workable. I understand and accept and admire the fact that the current minister says she's not made appointments since she's been in that position. But we have a new minister every year and a half or so. So what this minister does not mean the next minister might not do it. So it does have to be legislated in some way. And that's something I think we need to focus on very carefully. And as for the bulk interception, well, we are having to be guided very carefully by the Constitutional Court judgment in this regard. And we have to be very careful to do so because no committee wants a single line in a bill that they put through to fall short of constitutionality and allow any challenge to fall through. We just can't allow that. We can't accept that. So we have to be very careful to count every single word in this regard. But there was indeed a lot of civilians believe that bulk interception just takes in every phone call in South Africa. They don't understand and have never understood the actual need for that sort of activity or what it entails. So I think, and hopefully in our discussions in the committee, that has clarified that to some extent, but it's something we have to really tiptoe around in terms of the Constitutional Court judgment. Thank you, Chair.
Thank you very much. I think maybe we must avoid saying we can't allow that because we are still going to deliberate on these things. We can't say we can't allow it if maybe the public participation says they will allow that. So can we avoid saying we can't allow it? We are still going to deliberate on every other thing that was said. Honorable Sterbe.
It was on. I think it's on now. Thank you for the presentation. I think what we must do as ad hoc committee, we will test this against the findings of the high-level review panel, and if everything that the high-level review panel recommended, if that is contained in the bill, that's the one thing. Then the bill that was presented to Parliament. And I'm just going to talk on that issue of the wording of domestic intelligence, where it was a threat of opportunity, potential opportunity, threat, or a potential threat to national security. That was coming from the department in the bill. Now your response is to go back to the definition of the National Strategic Intelligence Act. Why was this brought in, and why didn't they stick with that? Whoever drafted that bill, that's just one thing. And then there's only one thing that the chairperson spoke to it. It is on the broadening to include or to identify. That's on the vetting and the tech threats to national security. Now my understanding is, and I think that's what I read through this, that vetting must be done on people who's working with secrets, put it layman's term. But how can you vet to detect a threat or something that might be a threat in the future? Now you're going to vet somebody, something that might happen in the future, or it might not happen, and it's too broad. And that's also what the high-level review panel said. We must narrow it. That to me is broad, and maybe you can tell me exactly. That's how I understand it here, and I might be wrong. Okay, the others also, I'll stop this. Thank you, Chair.
Thank you very much, Honorable Adebo with an H.
You are moving fast today, ne? Thank you, Chair. I would like to get clarity on the Section 41, the bulk interception, and the targeted legal interception. Because when I'm reading this, it says a bill will be introduced to address the interception and surveillance of communication in South Africa. Correct me if I'm wrong. Even when you conduct the bulk interception, there might be instances where you intercept communication within the country. Am I correct in that instance? So by saying to us, you will later on introduce the bill, are you halting the process of bulk interception in terms of getting a legislative mandate as per the Constitutional Court judgment? If I can just get that clarity, sir, Chair. Because to me, as I was reading, it seemed to suggest that we are halting the process until the bill is introduced. Otherwise, the committee can't give powers if the bill is still going to be introduced. Can I just get clarity in that regard, Chair? Precisely because of what the Constitution says in terms of Section 14, Chair, when it comes to privacy, especially 14D. Everyone has a right to privacy, which includes the right not to have the privacy of their communication infringed. So we need to safeguards in that aspect. We understand the need of bulk interception. It has to be done, but there has to be safeguards, and those safeguards, given the fact that regulations, sometimes we conduct our work behind closed doors, and the public might not have an opportunity to comment on such. So those safeguards ought to be spelled out clearly. Hence, I was saying this to me seeks to suggest that we are halting the process, but I will be corrected if I am speaking out of 10. The proposal now, especially in terms of the definitions, are we therefore saying we're removing both the opportunity and potential opportunity, and therefore reverting to the current definition, particularly the domestic?
Can I come in?
As you say,
they are not removing opportunity. I've got a question on that one. They are only removing potential opportunity and potential threat. So maybe you can help, because I had a question on that. Cover even myself. You are still on the floor.
Okay. Yeah, and I'd like to get an understanding why you still remain with the opportunity and not removing, because still the opportunity might be vague and open to abuse. So I would like to get a sense why remove one instead of both, given the fact that you had an opportunity to interact with all the presentation and public comments in that aspect.
Maybe before, still on
yes,
the,
you can add, Chair.
yeah, still on that question, because I might understand that in their work they don't only look for threats. If there are opportunities, they also look for opportunities. And maybe when they explain, because they definitely do that in their job, I'm not sure whether we would say it's legal or not. Is there no other term that they can use that narrows down? Maybe the problem might be with the term itself, opportunity, but the activity, I think, maybe to clarify me on that one. My little understanding is that they are doing that as of now, or is it not possible to narrow it down, or whatever? You are still on the floor.
Yes, I'm saying if you look into the definition of domestic intelligence, there is the provision of any internal threat or potential threat to national security. So it's already catered and covered, Chair, in the current definition. Yes, actually, you were assisting, so I'm assisting you to rephrase my question. So I'm saying the definition in its current form does provide for any internal threat or potential threat to national security. So why not remove both? Because I think this says it all and covers any potential threat that might arise in executing their work. So I would love to get an understanding why only remove one instead of both.
I don't think we are talking about the same thing, because you are saying potential threat. Opportunity might not be a threat, might be a good thing. That's what I'm saying. So now I see seemingly we are not saying the same thing. But, let them answer my question separately
Separate
and
from-
yours separately. You are still on the floor.
I see, there's a hand.
That one. Okay.
I just wanted to know perhaps the reference to that the minister made to a bill being worked. Is that not the RECA bill that's currently before justice? Because that is also answering the Constitutional Court under Bongane judgment. So are we not perhaps talking at cross purposes here? Because obviously we have to align ourselves with what, in terms of intersection, with what the Justice Committee comes up in terms of the RECA bill. Is that not what we're all talking about here and perhaps missing each other in the process?
Okay. I think they noted the question. You are still on the podium.
Thank you, Chair. On the proposal of having binding, I think it's on slide 3, number 9, the proposal for binding recommendation of the IGI will expose IGI process to legal challenges. It is proposed that where there is disagreement, the minister intervenes, and if that fails, the matter be referred to the Joint Standing Committee of Intelligence for final adjudication. So in essence, you're not supporting that we have recommendations are advised, but the proposal is that we need to have corrective measures over and above recommendations. There has to be corrective measures that will be binding. But I see here they're referring the matter to the to us to adjudicate, Chair.
No, not to you, not to this committee. Why do you say us?
The JSI.
Yeah, I understand.
Yes,
Why do you say us? Because
we're wearing two caps.
Okay.
I'm using the other cap of being a member of the Joint Standing Committee on Intelligence. Yes. But history has okay. Yeah, I must be careful now not to delve.
As long as you want it.
Yes, but it's in the public domain. It's contained in the high-level review panel report that not all the recommendations were implemented. And you still had the Joint Standing Committee on Intelligence, which also could not enforce some of the recommendation to be implemented. Other recommendation dates back years in memoria, decades ago, and they are still not implemented. What we're trying to, what the high-level review panel was trying to achieve is to make sure that we expedite the process of implementing and rectifying that which has been identified as being wrong and not delay the process of implementing. How are you going to, in this current form and proposal, going to make sure that, because it will depend on who serves in the committee at the time, if they have an interest, because there has been a Joint Standing Committee on Intelligence, and they could not enforce or ensure that recommendations are implemented. In this regard, we are trying to have legislation, regulations that will ensure that what is contained in the recommendations and remedial action of Inspector General, it gets implemented without depending on the feeling or the appetite of the committee at the time. So your recommendation, how will it assist in that regard so that we can be persuaded otherwise?
Can I get in on that one?
Yes.
My question is very simple. What do we have now? Don't you think it's effective? No, it might not. If it's not effective, it might only mean somebody is not doing his or her job. My understanding is that the IGI recommendations can be binding. Recommendations will remain recommendations. The certificates will go to the minister, and the minister, if they disagree, the IGI and the minister, the certificates are coming to the Joint Standing Committee on Intelligence. And I think the Joint Standing Committee on Intelligence can make them binding to the minister because they've got oversight over the minister. That is my understanding of what the situation is of now. The fact that the Joint Standing Committee on Intelligence hasn't been doing their job doesn't mean there's anything wrong with what we have now. That's my feeling. But what is your feeling in relation to that? Adding on his question on that particular or not question is request for clarification. You are still on the floor.
Thank you, Chair. Moving on, the issue of ring fencing the budget for the NCOP and IGI, is that sufficient to address issues of independence? If I can just get clarity, coupled with the issue of appointment of staff, given the fact that maybe the current minister is progressive, what then happens when the next minister comes along, or when there are issues of a disagreement that might arise in the course of executing your work, and IGI is of the view that there are staff complements that needs to be changed or restructured, and maybe the minister will have a legitimate argument of not supporting, but one might perceive that because of this current tension, you are deliberately sabotaging such. So don't you think we should also have safeguards in that aspect, as you are proposing ring-fencing the budget to ensure that we are truly implementing the recommendation of the high-level review panel? The other question, Chair, the apprehension, arrest, impede, and neutralization of an individual. Hey, you are running away from saying you want to arrest, ne? When you impede or neutralize, are you not interfering with the rights of someone or delaying? So can I just get a clarity? As you have alluded to say, it is also contained in the current legislation that governs intelligence, the issue of impediment and neutralization. What will be the safeguards in place to ensure that everyone understands and is comfortable that there won't be unduly compromised in terms of, because once you arrest, the right to remain silent kicks in. We don't want, I think Honorable Hanif on the virtual platform will also get in of people being detained for no particular reason. And then we said, no, we've neutralized or impede. So, if I were to make an example, if I were to impede the chair from conducting the meeting, maybe I can go and trap him there and then he's not able to. So please explain. And then I'll say I've impeded. The chair can say I've been impeded. So I don't know. Perhaps a clear safeguards and understanding of the impediment and neutralization. One might still say it's equivalent to arrest, but it needs a broader explanation for the public.
Can I get in on that one?
Yes.
Meaning the way we are doing things, I don't think there's going to be the second take here. Because we are clarifying all of these things at the same time. I don't think those terms exist in law. If you say neutralize, in the army might mean killing somebody. If you say impede, you might mean you stab somebody with a knife in order to impede that person or neutralize. So it means if you use those terms, you need to qualify them. Yeah, exclude some of these things. And that is and it gets the constitution gets in, you arrest. In law, you only have arrest. And if you have arrest, every other thing kicks in. You can't just arrest a person and say we made a mistake. That person can sue you. So those terms, maybe if you could understand, or how do you circumvent or maneuver around some of these things, or you neutralize a person by killing him, by stabbing him, by kicking him. It's a bit complicated. You are still on the floor.
Yes, Chair, because when I read the response, it said should be defined to include measures taken within the confines of the Constitution and the law to disrupt and prevent any threat to national security. So I thought perhaps you will then be able to explain what are these measures that are within the law and the Constitution to neutralize and impede, because I also had the similar understanding that the only applicable term in law is to arrest. So if you are saying impediment and neutralization, as I understand it from the defense, please give us a comfort and expand what are these measures and how is it different from arrest? And yes, Chair, the redefining of vetting. I initially I also had an issue because I thought you want to deal with criminal element using vetting. As you correctly alluded to the fact, Chair, that vetting, it's a choice. If I'm applying for the job, that includes vetting. If I don't want, I'm not going to be employed. And you're not going to pursue me to vet me. And now because vetting in its nature, it's not only focused on the person of interest, your extended family, my spouse. You want to know, hey, how did I grow up, my sister? So it's no longer about the person of interest. It extends to other people. So I would really would want to get a clear understanding on this redefining of vetting, whether or not it's going to be used to fight crime. In its current form, it's not meant for such. It's meant to ensure that, as we are the committee, not this committee, but Joint Standing Committee on Intelligence, if we're going to access highly classified information, we need to be vetted. But it has nothing to do with fighting crime on our behalf. So the institutions and persons of national interest, if they're not going to interact in any way with the classified information and document, why then want to use vetting? And are you saying the current provisions are not sufficient to deal with any potential threat to national security. You need a redefined vetting process. I would like to get clarity on that aspect, Chair. Let me drink water and pause there for now, Chair. I could not write everything. When I was writing a question, there were 3 pages ahead. So I might come back if the need arises. So I'm saying, Chair, given the time, please brace yourself that I might come back for more.
No, I've already declared that there would never be the second chance. And maybe I need to clarify the questions that we are asking, not that out of a sudden we have become very clever, but those are part of the reports. So part of what people said is in the report, because I see you are looking at Hadebe thinking that out of a sudden is very clever. Okay, can we get to Honorable Hendricks?
Thank you very much, Honorable Chair. Honorable Chair, it was very refreshing after listening to the Minister that she's acknowledged that this committee went out of its way to get the views of the streets through public participation. What is even more refreshing is that the Minister has in many cases responded positively to the concerns and recommendation of the streets. So I think we're off to a good start after this long delay to get the GILP Act on the table. We note that the Minister managed to maneuver around the right to strike. We heard from the intelligence general that the fact that staff can't strike has demoralized the intelligence services, so that they can't get their basic labor rights. And it's a concession that now they don't have the right to strike, but that the minister now don't have the right to lock them out. So that balances the playing fields. I'm glad that the minister supports my proposal for an alternative dispute resolution and other members. We may have to amend the Arbitration Act to allow this to happen, because arbitration will speed up a resolution of disputes. On the issue of vetting, I did mention, and I just want to reinforce that it is unacceptable that my religious leader, my priest, must be vetted by security forces. And we did recommend peer control, maybe accredited structures like they have for the medical professions and other professions. But to ask, and I don't mean this in a derogatory way, to ask spooks to vet is out of place in a democracy.
Honorable Hendricks, I think what we were trying to do is to clarify their responses. Tomorrow we are going to be deliberating on their responses and every other thing. That's when you can tell us your personal view on how you feel about what they responded on. So today, just clarify on their responses. Tomorrow when we are sitting, then you can come up with your view. I think now you are deliberating.
Yeah, I apologize. I seem to do it a lot of time, but it's nice to have. I don't like to talk behind people's backs. I like to say it in their face. But I understand, that is how you are running this committee. It is fine. It's not for me to argue. I also now want to find out, with the issue of torture has been raised several times, and for sake of clarity, I want to know whether the conventions that South Africa signed with regard to torture, besides the constitutional protections, whether the minister is satisfied that torture will not be tolerated, and that there are checks and balances. With regard to the bulk interception, that is a sensitive issue for us because my political party is in the Supreme Court of Appeal because of bulk interception by the DA and Action SA in the city of Joburg using a grabber. So the issue of bulk interception, I think the Honorable Khadebi raised that, and it is a concern. The matter of civilian oversight is very important, Honorable Chair. As you know, after the findings in the TRC, there was a strong push not to have an intelligence service for South Africa, and the compromise was for civilian oversight. So now the ring fencing, I would like to know why the minister has opted for ring fencing of the budget for the Inspector General of Intelligence rather than the budget that there be. And if you want independence, you can't make wolves kaapjagte. So shouldn't Parliament rather be responsible for that? Because if there's a fallout, then that ring fencing can be further fenced. So that is my concern. I know that I raised this in Parliament with the TRC that cases are not being dealt with, and the money is thrown in a big pot, and the compromise was that there will be ring fencing, and still there's very slow progress. So ring fencing is a concern. The very entity that must do oversight over the SSA, cannot be in any way dependent on them. Civilian oversight is very key, and I want to know to show good faith, if the minister can, for example, support stronger civilian oversight. For example, that the Inspector General of Intelligence be given the same power as a public protector. Now, tomorrow when we deliberate, I can then possibly challenge my honourable member Khadebi with regard to his position on that. Honourable Chair, you're not going to give us a second round. So, I would just like to take a bit of more time. The issue of, I want to know whose name is in the box. And I don't mean it in a derogatory way. We can't have 3 different super spooks. We need a name in the box. I'll tell you why I mentioned that. When the unrest broke out in 2021, the president called together leaders of political parties, and we had presentations by 3 ministers: police, intelligence, and I can't remember the third one, defense, and all different versions. And as you know, the president redeployed 2 of those ministers later on because that wasn't satisfactory. And I don't blame those ministers that were redeployed. It was the so-called super spooks that were advising them. We need to know as a nation, who is in charge of our security so that we know that the country is safe and and where the buck stops. So I hope the minister, will be able to give us a peace of mind.
Honorable Hendricks, I should think, why don't we focus on their responses? Because they've got to respond. I mean, they presented, and some of the things I don't think it's up to them. That they can report to another, can be asked in another committee. But for now, what they've presented to us, can we just focus on those? If I was to give you an example, you were talking about torture. I don't think they must answer about torture, because in their presentation, even in the bill, I haven't seen anything about torture in there. So can I just say, before you continue, we have got 10 minutes left, and can we just decide how we are going to work this thing out? Can we say that because there's a sitting today, after the sitting they respond, because in 10 minutes they can't do that? Or maybe tomorrow we give them a chance to respond, because I think it's time for caucus now. What would be the best thing? In 10 minutes, surely they can't respond to all of the questions. I see tomorrow morning. I see the minister is trying to protest. I don't think it's up to her to determine anyway. Let's hear from this side, and then maybe we can give her a chance. From members, do we come back this evening after plenary?
We could absolutely do that. I don't know that the department would need more than, say, half an hour to respond, or
No,
within an hour.
no, simply half an hour in the response after plenary.
Well, I've got a meeting till 5. We could meet after that, would be fine.
Other members? Or let's hear from them. Then the decision here is after 5, and then from them, what do they prefer? Tomorrow morning or after 5? Then we can ask from. Do you want to choose?
Yeah, no, I'm saying after 5, maybe I'll join virtually.
Okay.
If the facility will still be available.
Let's hear tomorrow morning or after 5.
Thank you,
From the minister.
Thank you, Chairperson. We'll really plead for after 5, because tomorrow is not possible. We are dealing with a situation that is prevailing in eThekwini. It requires all of us who are here to deal with that, confront that. So, yes, so we tomorrow, even if we can make arrangements to disrupt what we had planned for this afternoon, but tomorrow really, otherwise we can do the bill, but we have the country that is burning.
No, then it's after 5. It's agreed. After 5, we continue with the responses. Honorable Hendricks, you are still on the floor.
Let me conclude then, just to ask the minister to give us the peace of mind with regard to the question asked by Honorable Adepi about the temptation of her department to want to arrest. Thank you, Honorable Chair.
Thank you very much. I had said there's no second bite, so we after 5 it's the agreement. Thank you very much.
Maybe 5:30.
Yeah. quarter past
My
5.
Zoom goes to 5, so I'm running from.
You're still very young, you can manage running. Let's say quarter past 5. Then we be in here. And maybe, yeah. Okay, then the meeting is adjourned.